Hi everybody, this is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we are going to do a video for you where we talk about our recent opening statement that I prepared and was about to give in Supreme Court for the state of New York, county of Westchester. But I never got to actually deliver this opening statement because the case ended up settling. But I'm going to talk to you about what I would have said and do an outline, and then maybe even be able to show you some of the slides that I was going to use, and show the jury during the trial. So it's very cool. So I was going to start out the opening statement by thanking the jurors for being there and for talking about someone's voice and our opinions, our thoughts, our ideas. And I was going to say, look, in this day and age, in this society where we live, do our voices, our thoughts, our opinions, our beliefs, do they matter? And there's one place where I know for sure, where my co-counsel knows for sure, where the defense attorney knows for sure, where the judge knows for sure. Here, your voice and your vote, it matters. You are the only people who can make a decision in this case. Is what happened okay? Was it negligent? Should we allow this to happen? Or should we stop this from ever happening again, right? And so there's a little bit of an empowerment to empower the jury, to make them feel like they're the only people who can decide this case. And then I was gonna take them to a place. Like a lot of lawyers talk about space, right? And if you can think of a space, then you can start to imagine and you can start to create. And when you start to create something, as a lawyer giving an opening statement, the audience is there with you. There's something known as mirror neurons. So your neurons in your brain are somewhere because you're creating something, and then the audience, it's mirror neurons, they're also there with you. So I was gonna say, let me take you back to July of 2020, and we're in a hospital room in Manhattan, and the doctor is there, he's the surgeon, he's about to perform the back surgery. And the nurses are there, everything is ready. By the way, this is July of 2020, so this is peak COVID, right? COVID started in March, just a few months in. And there's a woman there, and she's about to be the patient. She's gonna have this surgery, and this is a major surgery where they're going to cut open her neck, go inside, move organs, like move the carotid artery, get into the neck, and have to do what's known as a spinal fusion surgery, but to her neck. And so I was going to talk about that and put them there and talk about all the scalpels and everything and everyone in the operating room. But then the woman just says, no, I can't do this. I can't do this. And she runs out of that operating room. She runs out into the hallway. She's in the elevator. Now she's down in the street, frantic, looking around, not knowing what to do. And then she just goes home. And I was gonna say, like, who is this woman and why has she just ran out of the hospital? And it turned out that that really did happen to my client. She had the surgery scheduled, but she asked the doctor, hey, can you guarantee that this is going to go well? Because this is a major surgery. People are scared to do this. And the doctor said, no, I can't play God. And so she did run out of that hospital room, but then later on she ended up having it a month or so later. So so basically then what I like to do after that is I like to talk about the fact that the members of the jury, right, the jurors, they are members of the community that are making a decision, and the standard is more likely true than not true, right? In New York, we have something known as the greater weight of the evidence. So if you take the evidence and it just has to weigh a little more, like 51 to 49. So that's important, because some people think that, especially when it comes to allowing for money damages, some people think that, well, if you want me to allow for money, especially millions and millions of dollars, you got to prove it to me by like 85% or 90%. But that's not the law. The law is the greater weight of the evidence, whichever side's evidence weighs a little more, right? That's all it has to be. It's like the 51-yard line in football, or, you know, if you say a glass of water is half full, one more drop, whatever analogy you like to use, but that's all it is. So it's important to explain that early, because then at the end of the trial, at the end of the closing argument, the judge is going to read the jury instructions to the jury. And what you notice is when I do my opening, I use a lot of the same language. Now some judges won't let you tell the jurors the law, because they'll say, well, that's my job, counselor. I'm the judge. I'm going to tell the jurors the law. But you don't have to be so blatant in opening statement and say, I'm going to tell you what the law is. Don't do that. But just use some of the operative words, like the greater weight of the evidence, or more likely true than not true. And I like to tell the jury that by the end of this case, you are going to know what we know, and you are going to see what we see. And that's why you're going to see that this is a many $million case. This is not some little fender bender or some sort of like fraudulent case. This is the real deal. And I'd like to say that you are the only ones who have this power to make a decision in this case. So then what I like to do next is I like to talk to them about who we are suing and why. Because, you know, they're just people. They got selected for jury duty. They're here on this case. They're like, well, why am I missing work? Why am I not with my kids or my family? What am I doing here? So who are we suing and why? So I explained to them in this case that we are suing an individual who, you know, just was negligent. He rear-ended our client. It happened on a bridge. And I tell them it has already been determined that he was negligent, because his car, the front of his car, hit my client's car in the rear. He was negligent. He crushed his car. I show photos of his car. The front was crushed metal. And this entire injury was thrust into my client's life unnaturally. So, and then I talk about that this trial will be about the damages. And the damages are all of the harms and all of the losses, all of the ways, what's been taken from her and what she's left with now and has to deal with now, both of those. And it could be economic, like future surgery costs, future physical therapy costs, future prescription costs, and we'll present that to you with a doctor and an economist. But also it could be non-economic, such as quality of life, doing things that, you know, she loved to do. So, and then I take them there. I take them to the date of the incident. This one happened in April of 2019. It was about 1:30 p.m. on a Friday. It was cloudy. It was 66 degrees. It was windy, and it happened on a bridge. And I actually had a Google Maps photo of the bridge where it happened. And she's a lady driving from Westchester to Brooklyn, and she was in the middle lane. She gets hit. And then when you come out, I actually drove that bridge to get to the courthouse. When you come out, it's actually very scary, because there's like this little concrete barrier, but it's very low. It's like maybe the height of your knee. And then after that, there's a little bit of a metal barrier. And then it's just the vast openness of the sky. And you see the water down below. It's very, very scary. And so what happened was, when she was rear-ended, her neck went forward and then back. It was a whiplash. Her knees hit the dashboard. There was smoke inside her car and outside. And the fire department actually came and responded to this smoke condition. They thought there was a fire, and the emergency ambulance came as well and treated her. But she didn't choose to go to the hospital. And I was going to tell the jury that the reason was because there's adrenaline and there's something known as epinephrine, right? Like an EpiPen. And when that happens and you see the smoke and you're in fear and you just want it to be over, you're not necessarily immediately thinking of getting medical care at that time. So she didn't get medical care, but her car had to be towed, and her car ended up being a total loss. Now, the damage to her car wasn't that bad visibly. There was some talk of the chassis or the frame being bent, and then the defendant's car, Now, my client's car was an SUV. The defendant's car was a regular sedan. His car was pretty much crushed in the front. So that was good in terms of property damage for us. And yeah, so that's basically what I was going to talk about. And then, you know, once I talked about that, I was going to go on to talk about a little bit about anatomy, right? So the brain is protected by the skull, and in the same way, the spinal column protects the spinal cord. And inside the spinal cord, when you have the entire spine, you have bone, which is the vertebrae, and then you have a disc. And I can actually show you. It's a little bit easier to visualize on this kind of model because this is the lower back, but the neck is the same. It's just smaller. So you have, these are the vertebrae and these are the discs. And what happens back here is if these discs, if they start leaking like a herniation, like the red part, it's touching these nerve roots. But the nerve roots aren't just what you see here, right? They're everywhere. There's small nerve fibers. They go all over, and these nerves, the smaller ones, they travel everywhere, to the arms, to the fingertips. That's how you have sensation. That's how you have feeling. They travel down into your legs. They're everywhere, right? But you don't only have the nerves, you also have the arteries, the arterial branches, you have the venous. So there's actually an app for your iPad called Anatomy for doctors, where you could actually visualize all this. So I actually had a visual that I was going to show the jury of the nerves, and then of everything, and the entire neck and everything. So, and the way that the disc works, you know, the actual disc that was herniated, the way that it works is you have the nucleus, which is the water, that's the center of the disc, and then you have the outside walls, known as the annulus fibrosus, which is a type of hard fibrocartilage. So for that water, that nucleus, to break free out of all those walls and then to start leaking outside and touching the nerves, causing pain, that's very, very serious. And part of the nerves is something known as a dorsal root ganglion. And that's almost like a bundle of nerves. Imagine, like, you know, trains going on tracks. This is almost like a train station, right? Where all the trains are. So that's like a dorsal root ganglion, like the nerve bundles. And it has nerve fibers in it and nerve fibers around it. And the place where the dorsal root ganglion is located is actually near what's known as the foramen. And the foramen are actually these holes where the nerves come out. You see the thick nerves that come out? If you could see, I'm gonna try to show. Here's the hole. See, that's the hole. The thick nerve comes out right there. That's the hole. But that's also where the dorsal root ganglion is, right? And that's the herniation is touching it. So it's very, very painful. So I was gonna explain a little bit about that, the anatomy. And then I like to do this. I like to talk about what the defendant is going to talk about it, but without saying, hey, you're gonna hear from the defendant. But I like to preempt, right, what they're going to argue, because I don't like to just give my argument, sit down, and then they're going to come up and they're going to say, well, what Mr. Frekhtman didn't tell you was, and then they're going to give their argument. So what I like to do is I like to say, before coming to court today, we had to consider. And what did we have to consider? Well, did she have this before? And there's something known as degeneration. From the time we are born, we start to degenerate. And what does that mean? Well, that's just living life, the painless aging process, right? Baby is born, that baby immediately starts to degenerate, right? Day 1 of life, day 2 of life, day 365 of life. Now they're 1 year old. By the time they get to be, let's say, 40-year-old, they're going to have some changes, some natural changes. But it's important to point out that this is the normal, painless aging process, right? It's painless, and it's just everybody gets it. And I like to talk about baselines, coping, and reserves. Now, baselines are where you were before the crash. Some people might be a 10 out of 10 because they have no injury. They go to the gym every day. They're like, super strong. They get hit, their baseline goes from a 10 to an 8. But some people, like my client, might have had some conditions from living their life, or she actually did have some prior car crashes, but the last one was in 2012, and the one before that was in 2009, and they weren't really affecting her. She had no medical treatment from 2012 up until 2019. That's like 7 years. No treatment, no complaints, working, living life, enjoying life, traveling. So the point is that if the pain was not there before the crash, but it started after the crash, and it has not gone away after the crash, is it all just a big coincidence? You know, is this all degeneration, the normal painless aging process? And this crash had nothing to do with it, right? Because that is what the defendants will ask you to believe. So I like to, you know, kind of front that and talk about it and make it seem like, come on, you're telling me it's just a coincidence? And the baseline is where she started, right? I would probably give her like a 7 or a 6. Coping is her ability to deal with this new injury. Someone who's already injured, already vulnerable, has less ability to deal with or cope with an injury than someone who's in perfect health. And reserves are like what you have left. So if someone is already fragile, already vulnerable, well, maybe now, even though this crash wasn't so bad, this is the crash that pushed the person over the edge. And now they can't deal with it, right? Because they didn't have very much to give. They didn't have very much in reserves to begin with. And you take your plaintiff as you find him or her, right? You can't say that I'm only going to hit, you know, really healthy people. You know, for example, if a trucker is driving a truck and he has a load in the back of the truck, and let's say a farm truck, and he has a load, and then another car hits him in the rear and comes out, and that farmer had eggs, and the eggs are all broken, is the other car allowed to say, you know what? You know, I'm sorry that your eggs are broken, but I'm not going to pay for them. Why were you carrying eggs anyway? You should have just been carrying ping pong balls, because if you were carrying ping pong balls, this same crash would not have damaged them at all. Right? And it's kind of like a ridiculous argument. So I like to explain that to the jury. And another analogy that some lawyers use, I wasn't actually going to say this in opening statement, but I just heard it from other lawyers, and it could be good in some context, is using the example of Bo Jackson. If some of you know, Bo Jackson was a famous player that played baseball and football. And he was like the best athlete in baseball, one of the best in football. He was like an amazing once in a lifetime, once in 100 years athlete. And then there was this game that he played, and it was a garden variety tackle, like a nothing tackle, just like you wouldn't think anything of it. Kind of like a little fender bender, right? Just a normal tackle. He fell down. And then after that tackle, he could never play either sport again. His career was over, and it just ended his entire career. And nobody would think like a little tackle like that, but somehow it led to like osteonecrosis in his hip or some kind of, you know, weird condition. And that's what happened. So that's just another example. So then I was also going to go into a timeline, and the timeline was actually going to have some of the same stuff. This is actually the timeline. I was going to do it on my iPad. Now, the way I do it is, it's a nice software. It's a 3D software. So you could see a 3D timeline. And the way it works is the timeline gets cast to a big screen, like a 70-inch screen, so the jurors could see it. But you could see it has like the car crash, then it has the next hospital visit, which was the day after, I believe. You have the physical therapy, and you have all the different MRIs, you know, and you just keep going through it. The EMG. Now, the EMG is very important. This particular client did the EMG in June. So this is good, right? Because the accident happened towards the end of April. By June, she's doing an EMG. Now, an EMG is objective evidence, and it was objective evidence of bilateral sensory median nerve neuropathy. That's what they found. And what that basically means is the sensory is the ability to sense things like hot and cold, sharp, dull. It's the tips of your fingers, like we talked about, right, that transmit these nerves, and the nerves go back and forth. So yeah, she had that both sides, left and right. The median nerve runs down the arm into the hand, and the ability to sense or feel things was compromised in the wrist. And she also had carpal tunnel syndrome, which is also the median nerve. The median nerve runs down the narrow passage in the wrist, is the carpal tunnel, and it becomes compressed and irritated. So this is all objectively proven by EMG, right? The EMG is testing the actual nerves through electrical stimulation. They're actually putting in like pads, and then you see the fibrillation potentials, you see the nerve activity, because nerves are electrical. Like your brain works electrically too. That's why some people say, hey, take a little salt in the morning, because the salt helps, you think better. It's the same kind of thing, right? It's all electrical. So this is an objective test, meaning it's not subjective where you could make things up. It's objective. So yeah, so this was objective in the fact that you could see the fibrillation potentials, the waves of the EMG results. It was done with a machine, and oftentimes doctors will listen. They will listen, and you could hear the EMG as well. You could hear certain things. And then she also had what's known as sensory motor peripheral neuropathy, affecting the upper and lower extremities, which are the hands and the legs. But what that means is it affects both the sense, which is feeling, and the motor, which is movement. Now it's the feeling and the movement is affected. And the peripheral nerves are all the nerves that are outside the brain and spinal cord, which, we talked about, right? The spinal cord and all those nerves, and the nerves go to the fingertips, to the toes, to everywhere. Your knees, your elbows, everything gets, that's your feeling. So the fact that this was positive, that these findings on the EMG, that was very, very helpful, because that's objective evidence. Now they can't say, hey, it's a liar, a cheater, and a fraud, it's an exaggerator, it's a faker, it's all degenerative. No, because she never had an EMG before. She had an EMG after this, and the EMG is showing all of this, confirming everything. So, so that's basically, like, I was going to go through the EMG, listening to the sounds. You could hear the sound waves. You could tell where upstream the problem will be if you consider it, all these nerves, almost like a river. By listening and by seeing the electrical activity, the waves, you could actually tell where upstream the problem may be. And she had the problem at, there was a C8 radiculopathy, which is in the neck. And then, I had some cards here. I wasn't going to say all of this. I'm just kind of going through my notes with you guys. I wasn't going to say all this, but like we talked about, basically, was this all just a big coincidence and the fall had nothing to do with it? Or, using your common sense, is it more likely that the car crash contributed substantially to the sequence of events? And see, that's important, because that's what the law is in New York. The car crash, the fall, whatever the incident was, it has to be a substantial factor in causing the injury. So here it was the car crash, as opposed to just being a coincidence, right? That your degenerative health conditions just happened to spring up from the mud at the very same time that you got into this terrible crash where there's crushed metal. And I know some lawyers say, if it crushed metal, imagine what it did to her spine, right? So showing the property damage. So yeah, so this was basically the opening statement. Some other notes here, but the other notes are more about voir dire, and I had some notes here also about serious injury. Now in New York, we have to prove a serious injury, and the easiest way to prove that, there are different categories, but one of the categories are just basically if you have what's known as a significant limitation. So as long as the limitation is not minor or slight or trivial, as long as it's significant or important, then you qualify. And it has to be permanent, so it just can't be like minor. And then the other category is significant limitation, so it has to be a meaningful limitation, and it has to not be permanent, but it has to have enough of a duration, extent, and degree. And then the final one that we could probably qualify under is 90-180, and that just means that in the 90 days out of the first 180 days, which is the 3 months out of the first 6 months, you couldn't perform your usual and customary daily activities, which I think she would qualify for pretty much all of those. So we kind of briefly like to touch on it in the beginning, because you don't want to not talk about it at all, and then it's all left for closing. Remember, closing, you're like summarizing what's already happened. So you don't want to, spring up something new. Hey, you have to find that it's a serious injury and here are the categories. They're going to be like, wait a minute, why didn't you talk about this before? That's already like the final act. So it's good to get everything out there as early as possible. So just looking over my notes, I had some information about the doctors involved and a little bit about life, the fact that they had to have injections. She also had pain relief injections, pain management. And, I saw one other lawyer when he was giving his opening, he said, look, when someone's going in there for those painful injections, pain management injections to their spine, they're not going in there to have fun. They're not going in there to make a case for a jury. It's a really dark time. It's they have this hope that one day I'm going to get better, that this is going to go away. But sometimes, that you have to put that hope on hold. You have to say, maybe next year I'm going to get better. I'm going to go fishing or whatever I love to do. And then after 4 years pass, that hope starts to dissipate, meaning that it's never going to get better. I'm going to have to learn to live with like this. This is my new normal. And I still like to look on the bright side, but I get reminders every day, and the reminders are pain that I feel. And that people want to be helpful. They want to participate. They don't want to be a burden to others. But people have good days. And on good days, they have what's known as pilot-like pain. So they're in pain, but the pain is like a little pilot light on your stove. It's always on, it's always there. But then other days it could be a lot worse. It could flare up and it could really be serious. But the good days are the pilot-like pain days. And then, things that she couldn't do, like cooking, writing, using a fork, not driving, not being able to use the stairs, the feelings like tingless numbness. And then there's also some stories. Like, for example, there was this story where she was taking the train, and she's like a young, vibrant woman in her early 50s. She's taking the train, and a lot of people are running up the stairs, especially like if you've ever been to like Penn Station in New York City, or, it's very, very hectic. And so she gets off the train and she's kind of moving slowly, moving carefully. Maybe this is one of the days after her neck surgery. And this older woman, a woman who's like maybe like in her 70s, comes up to her and says, "Are you okay? You're young. Why are you moving so slowly?" And it just kind of almost made her look in the mirror. And then the person that she saw herself as before was not the same person that she is now after this crash. And it was a little bit of shame and humiliation as to what this old lady said to her. So I like to use that sometimes if it's applicable, like the idea of shame and humiliation. There's also the idea of being immobilized. Now, she was an assistant principal. She still is an assistant principal at a school. And one of the things that she really loved to do was her work. She would help these children. She would take these schools that were like F schools, meaning really bad schools, and she would come in there and she would turn them into A schools. It's almost like that movie with Edward James Olmos, right, where the principal comes in and they're like, just take care of the school, make everything right again. But what they did was after the crash, after the surgery, they put her in a special office and they said, you're going to have a special accommodation. You're not going to use the elevator. I mean, you're going to only use the elevator. You're not going to use the stairs. And then, so that was like being immobilized, not being mobile. And I think people fear that a lot. That's almost like one of those, universals, like shame. Nobody wants to be shamed. Being immobilized. Nobody wants to be immobilized. So I like to use those universals because the universals are very, very important because the jury can relate to them, right? We're not talking about some boring, medical terminology, like what the heck is that? We're talking about things everybody can relate to. Fears, like the fear of falling and not being able to get up again, things like that. So I was, and then the other thing was that this was a school in a kind of a rough neighborhood. It was dangerous. There were gangs, there were drugs, there were fights. So she was almost like the monitor. In the morning, she would like gauge the temperature when people are coming in. She would look at them and kind of almost be, the school would have like walkie-talkies with the police and all these different organizations, because this is in the middle of Brooklyn, New York City, very, very busy place. A lot of stuff happens. So basically, I talked about the fact that she was going to be forced to retire, and because of the injury, and she lost the ability to protect these kids that she loved. She spent her whole life with kids, and now she lost the ability to protect these kids, right? She can't be watching them anymore. If there's a fight, she can't step in and help break up the fight. So that was something I was going to talk about. And yeah, so that's basically most of it. And then I had like I said, I had the timeline, like we talked about. The timeline had some of the information. I think it looks pretty nice. You scroll like this, and you could see it moves along. But on a big screen, it'll look nice. And then when you're done with it, you could click done, and you could play. And what it does is it creates a 3D texture, and it also shows you the whole timeline like that, so you could see the timeline, and each item is explained, all the treatment, and so we had that. We also had a bunch of slides, like we had 3D MRIs and color MRIs, and we also had illustrations. Like for example, she also needed a knee surgery, which was an arthroscopic knee surgery. So we explained, we had a doctor illustrator draw it all for us, and we could show it to the jury. And then we could also talk about the type of tear it was, which is like a parrot beak tear, because it looks like the beak of a parrot. I even thought maybe I'll show a parrot to the jury to shoot, because it really does. The tear looks just like the beak of a parrot. But yeah, so some of the medical records showing the spinal canal from the top view, showing all the nerves, how they run, showing there's a 3D MRI of the herniation, and showing how the herniation, because it's leaking, right? It's like a jelly donut, it's leaking. And when it's leaking, it's going into that spinal canal. And when you have that spinal canal, you could see it, right? It's almost like a pathway. It's an actual canal, and you have the cerebral spinal fluid, and then you have the actual like spinal nerves there, and then you have cerebral spinal fluid again, and then you have the ending of it, right? The walls of it. So you could actually see the herniation like getting in there, like as you could actually see and compare it to what she had before, because she did have an MRI in 2012, but in 2012, you know, it was a slight bulge. It wasn't touching the canal. By 2019, after this crash, that herniation is like into the canal, and it's already disrupting those nerves. So you could see from the top view, May of 2019, when she had the MRI, you could see a color view of the herniation in red, two herniations in red. They were like into that canal, and they were already into the cerebral spinal fluid. So then the next step would be into the nerves. That's really dangerous. So they were compromising that canal. Then we had calendars showing no treatment before, and then after. You could see a lot of dates of treatment. I think I counted over 200. And then we had, yeah, actually this view right here, you could see both. So in the 2012 MRI, you see there's like the actual spinal cord where you have the nerves is black, and you have a little white space. So there is a bulge, but you still see the white space, which is the cerebral spinal fluid. But then after the crash, that white space is gone, and that herniation is right into the cerebral, right into the nerves of the spinal nerves themselves. So that's very, very dangerous. So I like to use these slides. I mean, you don't want to get too descriptive with people, but it's known as the actual spinal cord. And you have arachnoid matter, subarachnoid matter, dura. The dura, I believe, is like the sheath that where that, you know, protects it. So it was going, you know, through that dura into the subarachnoid space, past the cerebral spinal fluid, into it was already touching the actual spinal cord. So yeah, that's why she needed the surgery, because that was very, very dangerous. If you don't do that, you can become paralyzed. You can get myelopathy. It's very, very dangerous. It's life-threatening. And then I had a slide that showed all of the different, you know, like I talked about before, the nerves, the arteries, and the veins. It's an interesting software, actually. Maybe next time I have one, I could actually, use the software on the iPad. And as you use the software, perhaps it would be cool if you could then cast that to, the big screen, and then you could talk, and then the doctor could explain it while they're on the stand. I think other lawyers have done that. I think that's permitted. That would be pretty cool because, yeah, it's a pretty cool software. You just basically, you see it has like arterial, so you add arteries. It actually has like a beating heart. You could add as many things as you want. You could actually see it like that. And then you can add veins. Now it adds the veins, lymphatic. I won't do lymphatic, but nervous, all the nerves. So you could see like here, all the nerves are in yellow. Then when you zoom in, you can zoom in to like, let's say C, well, you see the jaw there, C2, C3. Like this is around where she had it. It was like C4, C5. So when you zoom into there, you could see what's happening. You could see the vertebrae in here. And you see all those things going on. The yellow is the nerves, the red is the arteries, the blue is the venous system. But again, for a doctor to go in there and be cutting that out, I mean, that's so dangerous. There's so many different, especially, and you could rotate it. It's pretty cool. You could see the small ones, the big ones. This is for medical students, but it's very, very cool. So I think maybe next time I'm gonna actually do it live with the doctor. Of course, the doctor has to agree, but this is like when you get close, you see all the little branches. There's a lot of stuff going on in there. You don't want somebody cutting up and getting in there. It's so dangerous. And that's why we thought it was worth, a substantial amount. So the case ended up settling for $575,000, which we felt was a pretty good offer. The client was happy with it. And had it not settled, I would have given this opening. Now, the opening probably would have been about like half an hour or so. And then we would have had witnesses, we would have had the client, we would have had the surgeon, we would have had the economist. We were trying to reach some community witnesses like friends, coworkers. We weren't sure if we were gonna have them or not. If we would have, they would have been quick, like 5 to 10 minutes each. And then the defendant would have had 2 doctors. They had one radiologist who was just gonna say that all of these results are degenerative. Although the weird thing about it was that she said that the December, because the client had 2 MRIs, right? One in May, the accident happened in April. So in May, she had an MRI. So she was going to say that this is the defense radiologist, that the May MRI was degenerative, meaning living your life, not from the crash. But the December MRI does show a herniated disc, and that one is traumatic. So I guess she was going to imply that something else must have happened between May and December to cause this herniation. But when I looked at them, they looked completely the same. There's no difference. It's almost like a, like a sham argument, like a silly argument. And then the doctor, the orthopedist that they were going to use is a guy from New Jersey, but he actually sometimes testifies for plaintiffs. And then as a side note, the defense lawyer told me, hey, I met this guy golfing and I thought he was a really, charismatic guy, nice guy, and I just kind of started using him a little bit, and he agreed to do some defense work for me because he usually doesn't do defense work. He is a plaintiff's doctor. Although he does, I guess he does some IME's defense work, but I guess that gives them a little bit more credibility, right? Because if they do both, it's better than if you have somebody who's always doing defense, then you say, look, you're a hired gun, all you do is ever do defense. You've never said anybody's ever injured in like 50 years. So that they had that going for them. And then also, but that doctor's report wasn't really too damaging to us. It just kind of said that in a conclusory way that, hey, she got better, or hey, this is degenerative, but it didn't have any analysis, it didn't have any medical reasoning. So it wasn't really anything we were worried about. Okay, so I hope this was helpful. Let us know what you think. This was a deep dive into our opening statement, and I was happy that I was able to present it to you along with some of the slides, because like I said, it wasn't actually delivered in court. So, so you guys are the only people that have gotten to hear it. So let us know what you think. Let us know what questions you have, and we are here for you. Please like and subscribe to our channel, and we'll do some more lives and some more topic videos. If you have any ideas or requests, we're like DJs, you have any requests, we'll take requests, and we'll do some videos just for you. Okay, have a great day, have a great weekend, and talk to you very soon. Bye-bye.